The defendant was subpoenaed before a grand jury in an investigation related to drug trafficking. Prior to the interrogation by the grand jury, the federal prosecutor informed the defendant that he had a right to the assistance of counsel and that he could be prosecuted for perjury if he gave false testimony. He did give a false testimony, and the government initiated prosecution on perjury charges. The defendant then moved to suppress the admission at trial of his testimony before the grand jury. The Court of Appeals ordered the suppression of his grand jury testimony on the grounds that he had not received Miranda warnings prior to the grand jury interrogation. This case presents the question whether the warnings called for by Miranda v. Arizona must be given to a grand jury witness who is called to testify about criminal activities in which he may or may not have been personally involved, and whether, absent these warnings, false statements made to the grand jury must be suppressed in a prosecution for perjury based on those statements. I must say I don't quite agree with the fact that he was called in to essentially incriminate himself, seeing as how that goes against our Fifth Amendment right of not being compelled in any criminal case to be a witness against himself. I do, however, agree that not being read your Miranda rights is not enough of a basis to warrant being able to commit perjury in a trial.